This week on Intrigued Full Effect.
It's a beautiful thing that life continues on through tragedy and stuff, but it's also kind of a curse that you have to live your life and do your responsibilities and handle your business through these tragedies.
I'm Chandrea Thomas, and welcome to episode 52 and the first episode of 2023. Happy New Year to all of you, if you're still saying it. In this podcast, I talk about curious cases, disappearances, and other stuff. And today, I'm taking a deeper look at the Catherine Hoggle case. She's the Maryland mother who's accused of murdering her two missing children, Sarah and Jacob Hoggle, back in September of 2014. I've covered this case multiple times throughout the legal process. And it was a battle for Troy Turner, the kid's father, and prosecutors to get Catherine deemed competent to stand trial for the kid's disappearance. Well, last month, after 8 years of court dates and appearances, a Maryland judge finally decided that Catherine was not competent to stand trial, and based on Maryland state law, the murder charges against Catherine were dropped in November of 2022. At this point, Catherine is still being held at a mental institution with no release date in sight. Now many are wondering if she will ever actually walk the streets again, and that's something that Troy Turner thinks about every day. I spoke to Troy and got his thoughts about the outcome of the case, and I had a one-on-one interview with Catherine's attorney, David Felsen, to get his perspective on the case and the factors that got the charges dropped. This is what happened. So tell me what happened recently, because I know there was a major shift or change in your case.
Yeah, so we had a final hearing, and it stretched over the span of, it was 4 days, I guess 4 days of hearings, including, the deliberation and judgment that was given. And it was stretched over the course of about 10 days total. And then what happened was the judge determined that it wasn't, the way he said it pretty much was that it wasn't proven to what the extent of what considered to beyond a reasonable doubt in Maryland is, which is it's like 95 or 98%. And in his explanation, he essentially said, if it was kind of a civil thing where it was a preponderance of evidence, then it sounds like it would have been a different story. But since she has been deemed incompetent, the state has to prove it above a reasonable doubt. And he said they just didn't reach that mark. And a big part of that was what was not allowed into the court through the records to be introduced as evidence, even though it was allowed to be talked about in argument. So it was allowed to be used in the arguments, but not allowed to be used or considered for the evidence or for the purposes of making the decision by the judge. So there's a lot of things that came out that show that she's 100% confident, but those are a lot of that's not allowed to be used.
So at the end of the day, what is the situation now? So they pretty much dropped the charges, the original murder charges in
Correct.
the case, right?
Yes.
So all the stuff and neglected and all the other things that were kind of mixed in with that, all those things are just gone now. And so is
Right.
that accurate to say?
That is accurate, yes. So the original misdemeanor charges would have been parental abduction, obstruction of justice, and then the two misdemeanor neglect charges. So the first two, as she actually explained to me on the phone, and then when I looked it up, it was right, is the parental abduction only carries 60 days in Maryland. And she was about a year in when she was telling me on the phone about her charges, and that was time served, obviously. And that's another thing, is the fact that she knew what would be considered time served in a situation like this or not. She understood everything. But the second one is the obstruction. That was 90 days, so that would have been time served. So it would have been two misdemeanor neglects that carry 5 years each. So they can tack that to 10 years. Which, quite frankly, if that were the case, though, in Maryland, she probably would have served 5 of them if it was actual jail time. So, but what happens is, at this point, she probably would have gotten the 8 years time served, so she would have had 2 left on those. So those are dropped. And my point is that those aren't super consequential at this point. Those were initially pressed to buy time to try to bring her to competency to press the murder charges.
And so as far as the murder charges themselves, so those were dropped, but at some point, and this is what I think people need to be clear about, at some point, can those be recharged, I guess, if she's deemed competent? That's what it sounds like from what I was
Yes.
reading.
Yes, but like you said, people need to be clear about it. So there's definitely clarity in the answers, not just yes. So yes, they can be, and it's been pledged to me by the state's attorney. As long as John McCarthy's in that office, they will be. Um, the detectives have pledged to me that they will definitely charge her if there's a change and she walks out of there. But the clarification comes in. Her attorney at that point is going to say they're essentially warehousing the mentally ill. They're serially charging her just to keep her locked up at that point. That becomes now in the state of Maryland a question of rights. So unless they can show some kind of reasonable change that makes them believe that she could be restorable to competency by the courts, then they're just going to let her walk out again anyway. And the whole idea that she's going to be held there forever or for a long time, it's just not true. I think in 6 months there's a chance she walks out of there, possibly sooner. But in my mind, I believe within a year she will be walking out of there. I can't say it obviously definitively. It could be much longer.
You've been going through this whole thing for 8 years. I mean, 8 years. So your kids would be what, 10 and 11 or somewhere in there, right? So they would be, growing kids,
12,
and
yeah, 10 and 12.
I'm sorry, 10 and 12, excuse me. 10 and
Sarah would have just turned 12 November 20th, and Jacob would have turned 10 July 3rd.
Okay, got that. So thank you for clarifying that. Forgive me for being wrong on that. If by chance this occurs, let's say she is released within however months or years or whatever, how are you planning to move in your life with that? I mean, are you moving away? I mean, I'm assuming you're concerned about the child that you have with you now. So I imagine you have all these thoughts about how you plan to live your life moving forward with the things, as far as the circumstances being what they are
At
right
that
now.
point, we'll do whatever we have to do to keep him safe. I mean, that's the goal at that point. Just whatever I have to do, or whatever we have to do to keep him safe, it'll just be done.
So can she legally never have contact with him as a underage?
She can no. Well, there's no laws stopping her from anything, other than just the fact that she has no legal rights to it.
And so, you know what? In the midst of all these interviews and the course of the time frame that your kids have been missing, have you been able to look at legislative things, talk to your legislators about changing these laws and making adjustments? What's happening with that?
So State Senator Lee is going to be introducing the bill again that we're trying to rectify kind of a mistake that was made in Maryland when they took away the death penalty in Maryland. It used to be 10 years or to the maximum sentence, even of the crime you were charged with, that you could be held incompetent. So it took away this whole concept of secondary gain, that, well, I can just sit here for 5 years or whatever versus facing, the chair or life sentences or anything. So what would happen, for example, in this case, in Maryland, typically, if someone is, just from what I've researched and people I've talked to, if someone is arrested for murder in Maryland, they're tried and convicted, they typically get somewhere around 30 years. They typically serve about 15 or so. So in this case, if we can get it just put back to 10 years, then in what we've accomplished now would be, because what we have done through this case is we have clarified and created case law for, you can go from, that the charges can be separated in terms of misdemeanors versus the felonies, and carry that to 8 years versus it being a max of 5 no matter what. So that being the case, now you'll have 2 different classes of felonies as it should have been. Because right now in the state of Maryland, I'm held to the same bar if I'm Catherine Hoggle as a double child murderer as someone who stole a TV. It's literally the same bar. 5 years incompetent, and then you drop the charges. So currently in the state of Maryland, if you rob someone of $500, it's the same thing as killing their kids.
That's insanity.
Yes. So from there, what would happen is you would have the 3 years in the case like this, for example, you'd have the 3 years on the felony or on the misdemeanors, you'd have the 5 year on the felonies, and then you would have the 10 years on the violent or egregious felonies. That would be 18 years. That takes out the secondary gain of gaming the system the way Catherine Hoggle has, because if she goes in for 30, her attorney's going to tell you, you're going to serve 15 on good behavior and you're going to be out. So she would literally be held longer incompetent than she would actually wind up serving for a homicide charge in the state of Maryland, which is still sad. A big part of that secondary gain. And in cases like mine, where let's say you have a child who would be in danger, a minor who's in danger of being a victim, then now that minor gets to become age of majority, gets to become an adult, and can now defend themselves if this perpetrator were to come.
Do you feel like after all this time and all this effort and everything that you've done, that you've gained and won something? I know you still don't have your answers. She's still not convicted in the disappearances of your children. Do you feel like you've won anything in the course of this? I know you said something about case law. So is that any gain for you? I mean, do you sense any of that? Okay.
No, not at all. Once we get through January, if we can get these votes, I mean, my testimony is going to sound a lot pretty much it's going to sound like a big I told you. So it's going to be, I was here 5 years ago. I told you this was coming. I told you 3 years ago. Here we are. Are you going to do something about it now? I mean, that's pretty much my testimony at this point. No, I don't feel like we've necessarily won anything, because it's, I mean, where we're at, you still have a system that's completely broken, inside and out, on the justice side and on the mental health side. The things that came out in that hearing, from the records and from Dr. Adam Brown himself at Perkins, he literally sat on the stand answering questions with Ryan Wexler, the assistant state's attorney, saying there's a ton of things that should be considered. Whenever he was asked if they should be considered, he was like, well, yes. But he didn't look at them. And then when brought to his attention, no matter what, nothing would have changed his mind, even if it's something that should be considered and should be mind changing in that situation. He literally would contradict himself that way, saying, yes, this should be considered. Yes, it would, it's something that could change the outcome of a decision like this. However, nothing that could have happened in there would have changed my outcome. And no, I didn't look at it. He sat with her for 90 minutes and basically read, according to him, a few summaries of reports. Didn't even read the reports. There were things coming out through the nurse's notes and the records that he's never seen. But this is the guy who is making the determination if we can go after justice for my 2 murdered babies. I mean, it was a bad scene. And then the judge, like I said, I don't think he's an unfair man. I don't think he's a bad guy. I think that he's bound, or he felt bound. I think there's a couple of decisions from my limited knowledge and being in the courtroom and listening that he could have made that would have swung things differently in terms of letting in the evidence. I believe that was up to him, and he chose not to. Now, what determined his choice and what he was interpreting within the law, I don't know. So, so I'm not going to sit here and say that he was protecting her. What I can tell you is Dr. Brown on the stand, Dr. Adam Brown, was protecting, without a doubt, his own opinion, and maybe to him being a younger doctor and things like that, maybe he was looking at his reputation. I don't know. He was protecting Perkins' reputation, and in effect, at times appeared to be directly protecting her, but through the other two was definitely protecting her.
So when you look at this whole process, I know you said that your testimony. So when I ask you the question of what's next, that is what's next for you, or is there something else happening with that?
So there's definitely, will be in front of the congressional bodies of the state of Maryland. That's step one.
When is that? I'm sorry, excuse me. When are you going before them?
I believe it's January. It's either going to be January or early February. If I remember correctly, I believe January is when we go in. I'll find out, from my attorney and from State Senator Lee, who's the one pushing it. But there's that. There's, basically one of the things is that we're supposed to be kept abreast of any changes in status for her. If she's let out, if she escapes, if she dies, if she switches institutions, things like that. Well, one of the things is, even without switching institutions, she comes out of max security in the place and goes to a civil commitment. At a civil commitment, they do things like field trips. I have no reason to believe that that she's not going to possibly escape. The only reason I believe that she may not even try is because I think that she knows that she's going to walk out of there as soon as she's deemed not dangerous, and she knows exactly how to play that game with them. It was sprinkled throughout all the nurses' notes about her manipulative nature and how, she is lied and manipulated to, she says to everyone in the place at points throughout her records that her goal is to remain incompetent. She told Dr. Brown this as he's doing this.
So all these things are like, they're on the record. These behaviors are on the record. All this stuff is on the record.
But none of that was allowed to be introduced as actual evidence. It was only allowed to be used as argument. So what that means is it can be said to kind of sway opinion, but when the judge goes back and, he hears a lot over 3 days, wherever, it's not going to be in what he is looking at to make his decision. So, for example, if we had a jury, let's say they did it by jury instead, where the jury was going to determine competency or not, which I don't even know if that's ever a thing. Like, to my knowledge, it's always the judge's choice ultimately. But if that were the case, I believe 12 people sitting there just watching and listening, and then having that stuff to review, but also not having kind of the training and stuff of a judge where, okay, I'm blocking this out and this is what matters, where you're a human being hearing this. I believe 12 people would have said she's competent. When I walked out of there, there's not one person. I don't care if it was someone sitting there. I don't care if it was attorneys who I met throughout the process who came in and listened in, or if it's the media. Not one person said to me, yeah, it's a shame she's incompetent. What they said was, this is ridiculous that someone can game the system this way and get away with this.
When you were going through this whole process, you said it was like around a 10-day process of this last kind of round of court stuff that was going on.
So it was 4 days or so in court. It was like 3 or 4 days in court, but, it got kind of spread out. There was scheduling the weekend. Yeah, so the whole process was about 10 days, it seemed like.
So when you heard the decision, were you surprised, or did you really have this degree of hope that maybe it would go your way?
We knew what we were expecting was what we got. There was always a slight hope of just, it's clearly the right thing. It's clear that she's competent, but just the way that the law is set up in Maryland, there's so much emphasis put on the doctors and the medical aspect of it. It's so convoluted because it's not supposed to be a medical diagnosis. It's supposed to be a legal determination. But the way that Maryland has it set up, and I don't know if it's mainly Montgomery County, if it's Maryland as a whole, because all my experience obviously is in Montgomery County between the circuit and district court there. It's just so intermingled to where if the doctor says she's incompetent, she's deemed incompetent. So when we had Judge Jordan, he had some health issues, so it got turned over to Judge Bonifit. Judge Jordan, what he said that got us into where we've been trying to get for 8 years, which is this hearing for a judge to determine the legal determination. He looks at the final determinations, and he goes, so prong one, which is if you understand the system, understand, your charges, who your attorney is, all that stuff, understanding what's going on in the court process. Both sides conceded that prong one was met by her, that she was competent there. The argument was on what they call prong two, which is, can she meaningfully assist in her defense? Can she take direction from her attorney? Can she give input to her attorney? So what they were saying was that she did not have a full grasp of her legal strategy. Well, what Judge Jordan said in the court was, most people don't. Most lay people don't have a full grasp of legal strategy. He was kind of like, I don't remember exact words, but it was kind of like, that's what they pay us as attorneys for. That's what they have attorneys for. So that's how we got here, because he said this doesn't make sense that this would make her incompetent. So he schedules the hearing and does the right thing with all that. And then he goes out. Bonifit takes over. And what happens whenever we get to the end, he essentially says the reason she's incompetent is because she's not fully grasping the legal strategy.
Wow. So you have two judges with different opinions about
that. They have the same opinion that she doesn't grasp it.
Yeah, but as far as the significance of why
right.
and
right, and what was put on kind of kind of on display by Dr. Adam Brown from Perkins was that she has disorganized thinking. And here's what he said. He said she can keep up with the conversation. She's totally on task. She gets everything. It is completely fluid, wonderful. Until you bring up her case directly. He even said, if you talk about things in general with the law, with cases and things, then she's fine. She'll walk you through it. She's completely everything, But if you bring up her case directly or the kids where they are, then the conversation derails and she talks about things that don't necessarily make sense. That doesn't sound convenient to you, bro? It's like, are you serious?
Wow.
And then you have this entire record sprinkled with her being manipulative and lying.
The legalities of the case were complicated from the start, and there's a lot to look at. So I had a Zoom call with David Felsen, Catherine's attorney, to get his perspective on the situation. Check this out. At this point, where does the case stand? I know that there's been a lot happening with the case recently. So with everything that's happened over the course of all these years, where do things stand today?
Well, as of November 30th, the circuit court dismissed the criminal charges against Ms. Hoggle. She is currently being held under a Maryland statute, which is commonly referred to as a civil commitment. She is not free, but the criminal charges have been dismissed.
Okay, so I know there's this whole people kind of get it and don't get it. So people say, can she walk the streets one day? Will she never be on the streets again? What is the answer to that? Or is there an answer?
Well, I certainly don't have an answer to that. To ask it in such a general way, I think sort of misunderstands not only the circumstance of this case, but the criminal justice system in general. Unless someone is sentenced to life in prison, they will eventually get out. The question is when and under what circumstances. But Ms. Hoggle, as she sits now, as everybody in the United States, is innocent unless and until she is proven to have done something wrong. Those charges by statute were dismissed on November 30th. And so she is, and rightly so, under the law and in fact, is an innocent person. Now she's being held under a criminal statute, under a civil statute, no longer a criminal detention, because she does suffer from a mental illness, and she is a danger to herself and or the community. She will be evaluated periodically. There is a process by which the Department of Health figures out whether or not she is a danger to herself or others. But there is no date on which she will be released. It is an ongoing thing, and she's been held for the last 8.5 years. I would expect that she will be held for some time longer.
Mm-hmm. So are you continuing on to be her attorney from this point moving forward, or is this a matter of you're done with this case and then you're just moving on to something else, or is that just kind of dependent?
Well, I don't move on to other things and forget what we've done in the past. This has been a significant case here in Montgomery County. I've been involved since September of 2014. We have committed, my firm has committed substantial resources to assisting Ms. Hoggle and assisting the legal system. We're in this thing. There are no legal proceedings pending right now for me to have my appearance entered, but we are still her lawyers, yes.
So when it came to the final decision of incompetency, what was it about evidence or whatever came forward in court that created that situation?
Well, from our perspective, we didn't think that there was much question about the evidence. As I had mentioned earlier, for the last 8.5 years, every doctor that evaluated Ms. Hoggle had found that she was incompetent. At the hearing in November, there were really two issues. One was the competency issue, and then whether or not she was restorable. Doctors had opined for the last 2 years that she was non-restorable. In other words, they'd done everything to try and get her to be competent and that they were not successful. At the hearing, much to our surprise, the state tried to contest that evidence, even though they didn't have an expert testifying. What they did is they called the father of the children, Mr. Turner, to testify, to say that he thinks that she was malingering. The state argued that evidence, Mr. Turner's evidence, Mr. Turner's opinion, Mr. Turner's statements had never been presented to any of the evaluating doctors, and that had never been put to them for them to evaluate. That turned out not to be the case, because in 2015, Mr. Turner had filled out an affidavit saying that he believed that Catherine was malingering. Both the doctors at Perkins, which is where Ms. Hoggle is being held under the commitment to the Department of Health, and the state's own hired expert reviewed those affidavits and used those in their evaluations. Despite those affidavits from 2015, they still found Ms. Hoggle to be incompetent. Also, despite Mr. Turner's testimony, he had signed and filed in some collateral litigation an affidavit about Catherine's competency, in which he said that she was absolutely incompetent. So, in other words, at the end of 2015, he said she was faking, and at the beginning of 2016, he said she's absolutely incompetent. There were some other questions about Mr. Turner's testimony that I think question the credibility of it. The state then sought to impeach the current doctor who rendered an opinion of incompetency by using old reports. They were not successful with doing that because the old reports were not exactly the same, because every report is independent, but they were all consistent. And the doctor in this case, in this evaluation, stood up pretty well to cross-examination because he was right. It was not, the state didn't present any counter medical evidence or evaluation that would have changed the opinion. So that was the evidence that was before the court, and the state has the burden to prove competency beyond a reasonable doubt. In the face of all that evidence, I think the court had really no option but to make the decision that the court made.
I'm sure there's a lot of backlash and people, back and forth opinions about what you do. I'm just very curious, like, what is that like for you to handle a case like this, especially with the sensitive nature of it?
I have been called some of the most vile names in the book. I've had people impugn my integrity. I've been assaulted. I've been people attempted to intimidate me. I've been cussed at and cursed under people's breath. But this is what I have to do as a defense attorney, and I will continue to do it regardless of the case when the cause is just, and I will do it to represent my client.
So right now, Catherine, she's being held at the facility that she's been at the whole time?
Actually, as we talk today, I'm not 100% sure where she is. I haven't spoken to her in the last week or so. My assumption is that she is still at the Clifton T. Perkins Hospital, yes.
What do you think happened? Because I don't know if anyone really knows exactly what happened. Can you answer that?
Well, I certainly can't answer it. I wasn't there. I don't know what happened. But there's sort of, your underlying question, I think, is, did you ever learn what happened? Did somebody tell you what happened? To think that somebody 8.5 years ago, who, and there's no question about this, was in the throes of severe mental health crises, who was delusional, who was hallucinating, who had been missing for a number of days, to think that person, and by the way, and she is still demonstrating psychotic characteristics, and still has a diagnosis of paranoid schizophrenia, and still is taking a tremendous amount of medications, to think that person could relay an accurate version of anything that happened 8.5 years ago, the idea of it just strains credulity. There's no way that we would think somebody could relay an accurate rendition of what happened. If the person, forget that somebody's a defendant, if the person was a witness and you would say to them, 8.5 years ago, when you were diagnosed with paranoid schizophrenia, when you were having a psychotic break, when you were delusional, when you were paranoid, when you were hallucinating, when you had been missing for 3 or 4 days, what happened that day? And by the way, we're going to give it 100% credibility. You would say, we wouldn't believe that witness. Why would we believe anything that Catherine might have said during the course of this representation? It doesn't make sense.
Do you think this case will ever be solved?
It's interesting when you talk to a defense attorney, what we look at as the case is the legal proceeding. The legal proceeding as it sits right now has been resolved. And the legal proceeding is the state's attempt to sanction Catherine Hoggle for what it believes she did. Doesn't mean that she did it, it's what they think she did. That's been resolved. What other people may define as the case, I can't speak to. I just don't know.
Do you have any thoughts, for the family, both sides of the family, as far as them, missing the kids and them being gone and who they could be and would be today? Any thoughts about that? Because I see you have a family. I see pictures behind you there. What are your thoughts just as aside from being an attorney, just a person with a family and just seeing the tragedy in all of this?
This case is a tragedy all the way around. It's profoundly difficult for everybody involved in the case. It's difficult for the family. It's difficult for Catherine. It's difficult for the attorneys involved. I think the judge even said it was a difficult case for him. This is a tragedy. I can't, and I don't think anyone can, project out what would happen or what should happen or what could happen. We just have to take things one day at a time. And unfortunately, I know that's not a satisfying answer, but it is the answer. I can't, there's no way that I could put myself in that position, nor can anyone else. It's a difficulty for everybody. In this case, there were at least 1, 2, 3, 4, 5 medical professionals. There may have been more actually, but at least 5 that opined that Ms. Hoggle was incompetent to stand trial over the course of 8.5 years. No one opined that she was competent. That's how profound this is. Even the state's expert opined that she was incompetent in 2019. So, I think that people really need to keep that in mind when they're thinking about these issues, whether it relates to this case specifically or to cases in general.
I know people have, discussed maybe the whole issue and idea of looking at the law that is in place that's kind of been the center of this, aside from, the kids and everything else involved here, but just the law itself and how it played out. What are your thoughts on that?
I think that the issue that you're bringing up is that people say, well, we should be able to prosecute somebody who's incompetent because we should be able to prosecute them because that's what we want to do. I understand from an emotional standpoint where people are coming from, but from a logical and legal standpoint, it makes no sense. We don't try people who can't defend themselves. The Supreme Court has said it. Common law has said it. The state of Maryland has said it. Every state in the union has said it. You have to be able to defend yourself in order to stand trial for any charge. The desire for some other type of resolution is notwithstanding. We don't get past square one unless somebody is legally capable of defending themselves. I understand that people's desire for a resolution or whatever they think they're asking for, but to gut the system because they want a resolution in one case makes no sense.
Now back to my conversation with Troy.
They have in her records her faking falls before to try to get moved to medical because she admitted to this to them because she thought it'd be easier to escape from medical than from the max security, which obviously it would. Another thing is they said that they really don't treat them under the max security whenever they are incompetent. So you're supposed to be bringing someone to competency. So we're talking about people with profound mental illness, right? But you're not treating them.
Hmm.
Do you know why he said they don't? HIPAA. And no, the Hippocratic Oath, he said, is do no harm. Well, in actually giving them treatment at that point, bringing them to competency may not be what's best for them.
How is that?
Because they could go to jail or be accused or be tried for murder.
Wow, that's kind of twisted
He
up a
said
little
that.
bit there, don't you think? I mean, I'm just,
Yeah. So people say, well, it's a conspiracy theory that she's protected there. Well, no, apparently a lot of people are. The system in Maryland is so broken that not only do these people have more rights than their victims, not only does she have more rights, to be protected in killing my two kids, then my two kids have to be found or protected or anything for their rights or my living, Not only does she have more rights and privileges, she has more protections in the state of Maryland. And this literally was put on display on the stand by Dr. Adam Brown, where he actually stated these things. That no, we don't treat them because, well, it could be harmful for them. They might say something. He said they might say something, that incriminates themselves even.
let me just switch over really quickly to the kids.
Mm-hmm.
And so, in how you function in your daily life, how are you moving forward with that, especially considering everything that's happened recently and what you've dealt with over the course of all these years, of these 8 years? Do you have memorial things for them? I'm sure you think about them every day of who they could be, who they would be, and things like that. Tell me about how you process that, because it's got to be very difficult.
I mean, it is difficult, definitely. It is, it's one of those things where it's not really even a thought process at this point. We're over 8 years in. It's just, they're constantly on my mind. They don't leave my mind. So it's not a matter of thinking about them, not thinking about them. Like people have even said to me, I was going to ask you about the kids and the situation. I wouldn't bring it up if you weren't thinking about it. They're my kids. What do you mean if I was thinking about it, So, I mean, the process of going through the day is some days obviously are worse than others. It's almost routine. It's like I always say, it's amazing what you can get used to. It's kind of one of the things I was telling someone the other day. I said, well, it's kind of the blessing and the curse, and that's life goes on. It's a beautiful thing that life continues on through tragedy and stuff, but it's also kind of a curse that you have to live your life and do your responsibilities and handle your business through these tragedies. For me personally, whenever it gets really tough, then it's a matter of, just getting in front of the mirror and just having a conversation with myself of, here's what's happening. Your kids are gone. You have this going on at home. You have these issues. You need to, pay for X from search last year or whatever it is. Whatever it is, but kind of run it down. And then at the end of that, just look myself in the mirror and say, now what, now what? Answer that question and move from there that day. That's where I start. So I literally will ask myself out loud, now what? I'll answer out loud and then start moving from that statement.
Mm-hmm. Do you guys have like events that memorialize them in different ways throughout the year, or have you just kind of decided to back up off of that?
No, it's we do every single year on September 7th we do the vigil, and we will on like their birthdays and things, we'll I mean, it's not really a particular day because I mean they're brought up daily in our household. Their pictures are up. I had a family portrait painted that they're in where it would look like if it was all of us now, things like that. They're a part of our daily lives.
Mm-hmm.
And we have stockings up now, and there's one for Sarah, one for Jacob every year. So it's not a matter of do we need to bring them up or memorialize them, because they're a part of our everyday lives. They don't go away. They're my babies. I mean, they're whatever has happened, they're still my babies.
What about her family? Did anything ever come from them? In the midst of with the way things ended at this point, any communication with them?
Well, yeah, we have had communication. I actually spoke to her dad a couple times, and and the understanding was that he had talked to her some, and he goes up to visit her every now and then. But I mean, in court, in the records, it comes out that he's actually involved in her therapies and up there way more consistently than he said, and talks to her pretty much every day. I mean, for all I know, he's a part of holding her incompetent and continuing that, almost aiding her and staying that way. Because if he's involved in all that, who do you think they're probably talking to for an opinion? Because they never came to me. That was one of the things that the state's attorney said. In the beginning, she had lived with me for like 7 years. When they were deeming competency, whenever they were trying to figure out mental state, no one even interviewed me or her mom or her sisters or her brother. No one from Perkins ever reached out to anyone who had been involved in her life previously for any information.
Huh. That's very interesting that never, I mean, did it eventually happen? Are you saying to this day that never happened?
Never. I even called up there to say, hey, look, here's some things that may be helpful for you guys. Because I knew before, so they retried this. So they tried clozapine now. Dr. Adam Brown, he didn't even know what he was talking about because he had said, they asked him about, well, did you review the Shepard Pratt records? Because he was talking about how clozapine is this thing of last resort, and she had this terrible reaction to it, Well, in there, they used clozapine, and because he said that she had 2 failed trials. That's not true. The clozapine trial at Shepard Pratt was very successful. In fact, when she got out of there into the halfway house and then to the home, to the day program, she was still on it. She was on it for 9 months to a year minimum with no issues. The only side effect she ever had was it made her tired. That's something where had they reached out to me, they would have had that information. I can go on my phone right now and pull up the documentation from the day program that shows the clozapine and how much she was on.
So at the end of the day, what do you want people to take away at this point? Because I'm sure I'll be asking, kind of seeing how your situation goes as you testify and do all that stuff with legislation and all of that. But if there was a main takeaway from your entire experience that you want people to understand fully out of all of this and convey about your children, about your life now, about everything, what would that one thing be to get out there to people?
This does not affect you, especially when you're talking about states like Maryland where these laws exist. This does not affect you. This is literally a blueprint that's been laid. If you have a diagnosis previously, you can replicate exactly what she did. And not only that, but once again, these people are not being held indefinitely. Borderline personality disorder. You're talking about people like Jeffrey Dahmer and things like that. These are personality disorders. I honestly believe Catherine Hoggle is a personality disorder. So that's great. Treat the schizophrenia. That's fine. But if you really look it up, I have 1,000,000 times, it's less than 3% of schizophrenics are ever violent. That's not what caused this. When a schizophrenic makes a determination to be violent, it's because they're making a determination. If it's not that, then let's say there are those rare cases. Well, those rare cases, there was something in their paranoia that made them so scared that it happened. And they're not going, at that point, these people, if you look at it, they don't lie about it. They admit to what they've done because they think they were right. So this isn't something that doesn't affect you. That's why we're going to change the laws and things like that.
Any last words for all of your supporters through all this time?
Just, we appreciate them more than we could ever even express, from the people on the page to the people in the community to all the people who help with the searches, the media, every time I step up there now, because I appreciate, the media so much for what they've done in the area, especially. I always try to make sure to thank them, to let them know that we do appreciate them. We appreciate the fact that they've been there for my kids, for Sarah and Jacob. Yeah, the main thing is to let people know that it has to change. It's broken and it needs to be fixed, and not just the justice side of it, but honestly, Perkins' whole system needs to be blown up. They need to go in there and they need to determine, do you want to get people well? Is your job as this state hospital that's on the state payroll, is your job to bring people to competency and get people or get people well? Or is your job to protect the criminal aspect of them in a crime and to basically deflect justice from the victims? Because that's literally what they're doing. And it was stated in court that this is kind of their mission. I mean, you don't have, like, we gave you that map that Catherine received there, right? That showed incompetency leads home. You don't have therapy but you have stay incompetent classes.
When it comes to my final thoughts about this case, I do believe that there will be more developments over time. We're basically left with questions of what happened to the kids and where they might be. And here's another question. Will Catherine ever get out of the mental institution that she's currently in? And if so, will she try to make contact with the oldest child that Troy has living with him right now? And if court dates do occur in the future, David Felsen says he will continue to be a defense attorney for Catherine if he's needed. I have to admit that this is a tough case to process because after more than 8 years and the legalities of it all, there's still no justice or answers for anyone. So now I'm left to wonder, are the kids still alive? And if so, who's bold enough to keep them hidden and where? And if they are no longer with us, the family deserves some type of closure. I can't help but think of who they could have been and the lives they could have lived. Now, I also know that Troy believes that his children are no longer alive, but he says he will continue to fight to change the laws in Maryland that had a big impact on his case. And I will keep an eye on any updates in this situation as it happens. Again, I don't believe this is over by any stretch. That's just my 2 cents on that one. If you have a case that you want me to check out, just visit me on the Intrigued Full Effect Facebook page or email me at intriguedfulleffect@hotmail.com. Until next time, be safe and stay true. The views, information, or opinions expressed during the Intrigued Full Effect, Curious Cases, Disappearances, and Other Stuff podcast are solely those of the individuals involved and do not necessarily represent those of the host. The primary purpose of this podcast is to educate and inform. The host of this podcast assumes no liability or responsibility for any activities in connection with opinions shared in the podcast. The podcast and blog associated with it shall not be used in any legal capacity or as a basis for expert testimony. Any copyright material in the podcast is approved by the owner or is part of the public domain. Music by Pond 5.